Hello, and welcome to the inaugural episode of the Bar Exam and Chill podcast. I'm your host, TJ. I'm here today to talk shop and break down strategies that are going to get you to pass the bar exam, hopefully with as little stress as possible. So you may be asking yourself, who is this guy? Like, why should I trust this internet bum when it comes to the California and the UBE bar exams, which I will be focusing on? You might even have some questions as to how the show will be structured and how you can use it in your studies. So let's get into this and more. And also at the end of this episode, I'm going to go through an outline of all the discrete topics that you're responsible for knowing in the 7 MBE topics, so that if you haven't bought a prep course, you'll have a comprehensive understanding of like each subject that you're responsible for knowing. That can help you self-study. All right, so I'm a licensed attorney. I graduated from USC in sunny Los Angeles, California. Fight on. And after practicing for about 5 years, I decided for personal reasons to move to a different state, which was a UBE jurisdiction. And to my horror, my license would not be transferred from California. I learned that unfortunately I would have to take the bar exam again. California is like a holier-than-thou state that looks down upon all ye other lowly states in the union. You can't be admitted by motion, so you have to take the bar exam. You're shit out of luck. And so you have to, unfortunately pay for character and fitness and all the, entry fees to take the bar exam again. So because you have to do all of that over, which is fairly miserable, I did not want to pay for another prep course. So in California, I used Barbary, which I liked, and I thought it was excellent. But, I didn't want to pay thousands of dollars again. So I kind of put together my own study materials and program for the UBE. And I, heavily relied on AI, which is amazing and is a great free resource that you can use. I'm probably going to talk about like prompts and stuff that I used for ideas for anybody who's self-studying. I did take the February 2026 bar exam for the UBE. My score was a 292, so I did well enough without a prep course to be admitted in any jurisdiction, any UBE jurisdiction. It's a high enough score for all of the states, so that's kind of my qualifications here. Honestly, I just have like a little bit of downtime, and as I was studying with the free resources that are available, I couldn't really find like exactly what I wanted, and I wanted to try and create basically what I want. I mean, I have all my notes and everything from studying, and I've got a little bit of time, so I figured I will try to give back to the legal community and just share all of what I learned and my notes and stuff for free. And I'm hoping that somebody out there will find some use to all this, and maybe it'll kind of help you feel a little bit better. I know the anxiety of going through the bar exam is absolutely terrible. So I kind of intend for this to be something that you could actually use, this podcast along with AI, to basically just prepare on your own. I think this will be really helpful. In future episodes, I'm going to actually just focus on the past exams, the essay questions. I'll be going through the hypos and, teaching all the mnemonics. Oh my gosh. Mnemonics. It's that's kind of a hard word. That are good for, utilizing for the rule statements and the elements that you have to reproduce on exam day. And I'm going to focus on like the previous exams specifically. But for this episode, I just figured I would kind of let you know who I am and talk basic strategy. So this will be comprehensive. I just want to go over like how to study for the bar exam. And you can use this also as a supplement. This podcast will be useful for anybody who's actually paid for Themis or Barbary or any of the other prep orgs that put together content. You can kind of refer to this as well. The more that you use, the more you refer to, and the more you practice, the better you're going to feel on exam day. So let's see. I'm going to just focus intensely on the 7 MBE topics. So you have these 7 MBE topics. Those are tested on the multiple choice section of the bar and also the essay portion. And then, depending on if you're in California or the UBE, and some jurisdictions are now transitioning to the next gen bar, you'll also be responsible in the essay section for these other discrete topics like, secured transaction. In California, they have the California specific evidence and civil procedure sections. I'm going to focus really heavily, at least for a little while, on just the 7 MBE topics because those are tested on both portions. And if you really get down all of the rules and elements that you need to know within that, sphere, you're going to probably pass the bar exam. I mean, you obviously you're going to need to study the other things that you're responsible for knowing, but the bulk of the test is going to cover those topics. So I want to focus within that, at least for now, and just kind of help you know how to study and how to prepare and what you need to do to be ready for exam day. I guess if you've ever worked out, I stopped doing that when I became a lawyer. I was just too lazy, I guess. I didn't have time to hit the gym like I was doing before in law school. There's basically like 2 theories that people generally ascribe to. People that go in and they hit the gym really hard for like 30 minutes. They get in, they get out. They do all their stuff really heavy. They do a really difficult lift, maybe some sprints. They get it all in and they get out of the gym. And there is another theory or another way of working out developed by this guy, and it's called Grease the Groove, which I think is pretty good as an analogy to how you should study for the bar exam. Basically, greasing the groove is instead of doing an intense workout within like a 30-minute period, you're just going to be grinding, do like 5 pull-ups and then rest for a little bit, 5 pull-ups, kind of all day long. You're just hammering through smaller repetitions and what you can do throughout the day, and you get stronger over time that way. That's kind of how I approach the bar exam. There's 2, basic ways that you study: active studying and passive studying. I kind of did a lot of passive studying, so that's why I wanted to create an audio resource. And in these future episodes, while you're at the gym or whatever, I'm going to go through a hypo and literally read the essay and go through an issue spot and then go through the call of the question and how you would answer it, how you would structure the essay, what the rules are, and all that fun stuff. So, passive studying, I did a lot of like consumption of lectures and people talking through the actual bar exam topics and all the stuff you need to know. Kind of just did that all day long. Like if I was cooking or even if I was taking a shower, I would just have basically lectures running at all times just to go over and over. I mean, when I took the bar in California, I really didn't want to take the bar again. I practiced with lawyers that failed the first time. So if that's happened to you, or if it does happen to you, it's not the end of the world. I practiced with some really competent, talented lawyers who failed the bar. It's obviously not ideal. But, that first time I really went gung-ho and I was studying all hours of the day and night, and I was a little bit more stressed than I think you needed to be. There's some pretty basic strategies that I feel like if you get all of the material under your belt and you're working through everything and doing your best, you're probably going to pass. I mean, you got through law school. So just, as long as you're grinding it out, it's a marathon, not a sprint. Burnout is real, so you don't want to like just totally overkill. I mean, that's kind of why I relied a little bit more on passive studying, I feel like, because it's not as intellectually rigorous. You're going to have to do the heavy lifting of sitting down to memorize, and actually there are some pretty difficult topics that you will have to spend some time thinking through the nitty-gritty details. Especially, I know you're going to be responsible for knowing all of the different sort of designations in property and all the vocabulary there and what it means specifically. That kind of takes a little bit more actually sitting down with it, and that's pretty tough. But as long as you're, I think every day you should be doing like 30 to 50 depending, MBE questions. If you don't have, the prep courses like Barbary and stuff, they have like NCBE, like real sort of test questions that you can go through, and they have like a huge library that you can just sit and do multiple choice questions a lot. And that'll be great because that'll teach you the actual application on like little mini hypos. So you go through those, and those are applicable even to the essay section. You can kind of, as you're taking a ton of those MBE questions, you're learning like, how does the rule that I'm responsible for knowing get applied to this little mini hypo? And the more you see, the better you're going to do. So when I moved and I started studying for the UBE, I kind of crammed a little bit more than I would have liked to. I just like physically felt ill having to study for the bar exam again. So I did it in about 6 weeks, but I did a lot of just AI. You can ask it like generate MBE questions on this topic or in this testing these kind of rules or whatever. And I kind of did it from memory. I developed like an outline I remembered a lot of like the actual topics that you're responsible for knowing because I studied so hard for the California one. And at the end of this, I'm going to go through, the MBE actual discrete topics that you'll have to know just as an outline so that if you don't have a prep course, you can take notes on it, and that's like what you need to know basically. Let's see. So basic tips and hints, at the end of my study, I basically crammed really fast. So the more that you see of previous exams, that's really the better you're going to feel if you've seen a bunch, right? So that's kind of why I wanted to focus in these future episodes on the actual essays. You want to ideally actually sit down and do like a timed test of yourself on both the multiple choice, the MBE, and the essay section, just so you get a feel for how kind of fast you need to be moving. You need to be a little bit under a little bit under 2 minutes as you move through the multiple choice questions. Some of them are longer, some of them are shorter. You don't want to spend too much time on one. At the end of the day, if you're kind of stuck, you're just going to have to pick an answer and move on. One tip that I heard that was really helpful to me as I moved through the multiple choice questions was a lot of times these multiple choice questions are pretty close. You might be between two answers or you're a little bit unsure. Both of them sound pretty good. So one tip that I heard that I found useful on the actual exam was, instead of looking for like which answer is the better answer and trying to convince yourself to pick that answer, you can actually kind of think through both answers in which one cannot be the correct answer. And when you view through that lens, for some reason, I found that it actually does come into focus, and you see like, oh, there's a reason why, B can't be the correct answer. And so you can kind of go with the other one. I will probably do an episode on actually going through like MBE multiple choice stuff. But, if you learn all the rules and stuff for the essay, that's also going to be applicable for the MBE. They both are mutually reinforce each other. So if you're studying for one, you're also basically studying knowledge that's useful for the other, which is great. I think basically, again, it's really important to try and keep, as you prep, you've got a couple months or so, try and keep it in mind that you don't want to burn out, and it's important that you get enough sleep and do all that stuff, like eat, relatively healthy and stuff, so that your study hours are actually well done. They're useful, and you're able to absorb and comprehend everything that you're actually studying. The AI will break out outlines. So if you tell it that you want an outline for whatever discrete subject matter, it will generate them and they're pretty good. I mean, they're basically, whatever they do on the magic end with the training, they've got a bunch of bar data that they're feeding the machine. So it really spits out like perfectly all the bar outlines. And within those, you can the great thing about the AI that I found was you can ask it questions and stuff. Obviously, the AI will have like hallucinations or things that it gets wrong a little bit, but actually it's I found that it was very accurate. And, one of the things that I've heard, but I do believe that this is true, the essay portion of the bar exam is really testing your ability to analyze. And so even if for whatever reason you get a issue that you don't know the rule for, you don't know what the actual law is, you can actually just like make up what would be a reasonable law and apply that on the test day. And I've heard that the graders will award points for that if you get the law slightly wrong or you sort of make it up, as long as it sounds reasonable and you're applying it to the facts on the hypo pattern. So with that in mind, the hallucinations that the AI might have, I think that largely, at least I used and relied on Google Gemini and Grok. Those are kind of the ones that I liked. But I know people use ChatGPT and the other one, and Claude, which is I've heard that those are excellent as well. I'm sure it's pretty much the same. If they do come up with like stuff that may be wrong, I actually think it's probably not like the biggest deal. I mean, obviously you want to be studying the correct law, and I think most of it is correct. But as you're asking it questions, it will really break down what you need to know and how to analyze questions. I mean, they do a really good job if you actually just present it with hypos. You want to be thinking like a lawyer. So most of these things within the law, like for instance in property and business associations and contracts, you want to kind of be thinking like, who could face liability in a lawsuit? Why would someone be sued? And who would actually lose or win the lawsuit? The different various counter arguments that you might encounter from somebody brings a lawsuit. They're arguing, hey, you should be paying me money. Well, why? You kind of want to know like the just general practical information. You kind of want to have like all that in your mind, like what could go wrong in any given situation. Obviously in contracts, they test heavily like somebody fails to deliver or somebody screws somebody over or lies or they don't carry out their end of the bargain. So for each of those kind of situations, you want to have in your mind how that would be dealt with. In business associations, obviously people in real life, you kind of want to think like, okay, if you have an LLC and you've got partners, what if somebody, gets cancer and dies, unfortunately, or if somebody breaks the law or, commits you to something you don't want to pay for. Those are generally the situations that are tested on the bar. You want to have a pretty good understanding of how those like break out and how rules that you're responsible for knowing get applied to those situations. And that's why I'm saying, with the AI, you can really, what's great about it is with Barbary and the actual prep organizations, there's not a lot of interactivity. I mean, they're just like, lecturing at you. You have the outlines, you're reading through them, and there's not really, you can't really ask anybody questions. You're sort of just on your own a little bit. I mean, obviously it's very helpful to have somebody directing you with what to know, but you can't be like, oh, I don't really understand what happens in this weird nuanced situation and fact pattern that's being presented to me on this past exam. Whereas with AI, you can actually ask it stuff and interact more. So that's what I'm saying is it was really helpful for me to ask it like literally, what would I do if somebody did this? Or even as you might have, questions that bubble up naturally as you're studying. Hey, what about it in this situation? What would I do? And you can kind of go into Gemini and actually ask it like who would face liability and why, or if in family law somebody moves to a different jurisdiction and they're there for not 6 months, how would it break down with alimony versus the actual child custody, and how do those break out? And the AI will actually generate answers to those specific circumstances where you couldn't get coaching like that from these prep orgs. I mean, the other thing that's useful to know is like in a lot of these topics, especially in evidence and like criminal procedure and community property, basically you want to have like a canned paragraph that almost any time you see an evidence question, you can start with, just without even thinking, you're just going to generate like, what is logical relevance? What is legal relevance, right? It's a fact that you got to have these sentences like down cold for exam day where it's like, it's a fact that generally tends to make something more or less likely. And then legal relevance is that 408 standards for if the prejudice doesn't substantially outweigh the actual utility of the evidence or whatever that actual, we're going to go through like the actual language you're responsible for knowing. I'll be a little bit more prepared when we're going through the hypos, but I'm just saying you want to have like a canned paragraph pretty much for the top of those. You're going to analyze those pretty much every single time you're going to encounter those. I mean, anytime that there's evidence, there's going to be a question as to whether it's logically or legally relevant. So you're just going to want to spit those sentences out on exam day and say, and then analyze, here, is it logically relevant? Here, is it legally relevant? Basically, the formula that I feel that the exam is testing you on is, they obviously in law school, everybody learns IRAC, which is issue, rule, application, conclusion. That is going to be basically the standard that I used as well. Just it's not really a very creative exam. They're testing you on literally just your ability to spit back that kind of formula for analyzing. So I literally would write, here the issue is blah, blah, blah. If there's a leasehold, who gets cut off from liability in X situation. And then, okay, in that issue, we've got this fact. You've got to pull from the facts. The facts are really important, right? So in the hypo, you want to be looking for... Oh, that's actually a distinction that is interesting. So in law school, you have these open-ended issue spotters, right? Where it's just basically like put down the entire syllabus that you learned in the whole semester, get it all down onto a page. In any issues that you spot as you go through the facts, just start writing. Just go through everything and just blurt it all out onto the page as much as you can, right? You want to just show the professor, I learned everything all semester long, and just blurt it out as much as you can. On the bar exam, it's a little bit different. They're going to have a lot of red herrings actually in the hypo, where there are facts that trigger a law that you're responsible for studying and knowing, but they do not ask about that, right? In the call to the question, they will specifically ask you, I want to know who's liable in this situation and why. And you've got to focus on that and not get distracted by all these red herrings. There's stuff that, is law that you're responsible for knowing, and it may apply within the fact pattern. But if they don't ask you that, I wouldn't go off on a tangent, because I don't think you're going to get a lot of points for knowing stuff that it's not asking you, basically. I think that's a pretty important distinction. Like in law school, you really just want to go through and spit out everything, basically. So that's one key distinction to know, is really just try and focus on what they're asking you. Again, I wanted to focus on actual NCBE previous exams. So like I said, I was like cramming at the end, and I do think it's important for you to understand what it's like to take a test under time conditions, but actually writing out like every essay is so exhausting. I would only do that a couple times, really, as I studied. So how I kind of approached it was I would go through the essay, look through the hypo, look at the call of the question. Can I answer that question? And have a little, note, a little Word document or whatever open, and I would just do like quick note jotting, just like logical relevance, legal relevance, and then in my head, can I spit out the law that I'm responsible for knowing? I mean, if you're like in a torts hypo, right, you just want to go automatically to breach, duty, causation, actual and proximate, and then damages, right? You just want to be able to know in your head, hey, I'm dealing with a negligence question here. Maybe the call of the question is asking me about a negligence issue. And I just kind of would jot down, like, here's the issue, right, for that they're asking me about. And then in my mind, like, can I reproduce the actual law that I'm responsible for knowing? I wouldn't write it out. I would just kind of say it in my head, right? And then if I could say it, just move through quickly. If I feel comfortable with the question, I'm not going to, like, actually write out a full essay. But you're just going to kind of want to look through and be like, if I got this on exam day, could I answer the question or not? If you can't answer the question, it's probably good to sort of think through, basically, like, what would I do? How would I approach this on exam day if I got this and I wasn't sure? What kind of law would I guess or would be a reasonable law here that I could apply? And then obviously you want to go and look at the model answers to see what the actual law on a good answer might look like. And for MBE, you can't really get through AI the actual... I will say that if you ask, like, for instance, Gemini or Grok to generate, like, MBE questions, they're not going to be as sophisticated or as intense as actual MBE questions. That's where, like, the prep organizations, they have access to some of those NCBE related questions, and they're, like, more representative, I would say. They're a little bit easier, but I mean, obviously, if you're asking Gemini to generate MCBE questions, it's testing you on the rules and the law that you're supposed to know, so it's still helpful, and you still will get some of them wrong and stuff. They'll still be tricky, but they're not going to be quite as intense as the actual bar exam. I definitely did notice that when I went into the UBE and I did the MBE questions on the actual bar exam, the level of difficulty and the actual sophistication of what I was being asked was a little bit higher than the AI generated ones. I mean, I knew the rules and I had practiced and stuff, obviously. So, I still did good, still got in that 146 range for the MBE, which is kind of right where you want to be at. I feel like that gives you a little bit of leeway for the essays to get a passing score. But, you can buy so the NCBE has like these 21 questions that they have for free. Basically, you can look at 21, right? You want to preferably see like a few hundred. If you don't have a prep course and you're not being given to them by like Barbary or Themis, they actually sell like bundles of them. Probably worth buying if you haven't taken the bar exam before. Like NCBE will have like a bundle of a few hundred or so that you can actually purchase. It's not going to be nearly as expensive as a prep course. And then you can kind of go through those MCBE questions, and you would kind of want to do it like under a time condition, or just be aware of what the time constraints are like and how you should be moving. It's pretty quick. I mean, the essays are going to be a crunch, right? On the 30 minutes for one of these hypos is really tough. So you're going to want to be typing fast, and that you're going to feel some real pressure on exam day to actually get everything onto the page. You kind of want to have that in your mind, like what that 30 minutes feels like. But again, I think actually like doing a timed essay where you're physically writing out every single sentence that you would be writing out on exam day, that is mentally and physically exhausting. And if you're doing that like all day long or just every day, personally, I would totally burn out. And I would, like I said, I mean, when I had to take the bar exam the second time, I felt physically ill. Just even having to approach this material again, it was just so miserable. So you kind of want to do like, you want to make it so that you're not like in total physical agony the whole time that you're studying. I'll try and make it as fun as possible. I mean, that's what I'm going to go through. That's what I'm going to try and do when I go through these hypos, right? You've got these mnemonics, the stuff that they use to try and remember all of the rule elements. I feel like every bar examiner has, and every prep org tries to have a few fun ones that are kind of easy to remember on exam day. For instance, if you were presented with like an adverse possession question and you wanted to recite all of the elements, one famous one that is used is a hoe on every corner, or a hooker on every corner. Either one, right? It's kind of fun. A, actual, hoe, hostile, O, on, open and notorious, every, exclusive, corner, continuous, right? You've got the my legs, which we'll be going through for property. There's all these little tips and tricks that we'll try and go through. What's that other one? There's one for, there's one for transferred intent torts. That's kind of fun. Big ass fucking titties. You got battery, assault, false imprisonment, trespass to chattels, and, trespass to land. Those ones, they have the transferred intent. So there's all these like little tricks that you can develop over time. And I feel like, Grok, obviously, as the AI is a little bit more unfiltered, it will generate some of those as you go through. It can be kind of fun to even create your own. As we go through the essay hypos in future episodes, I'll try my best to come up with some fun ones that are easy to remember on exam day. But you're not going to have a mnemonic for every single rule element and rule thing that you need to repeat on exam day. Some of them you're just going to have to know, like, 1, you got to have res, 2, it's got to have trust property, blah, blah, blah. Some of them you just are going to have to know cold. And unfortunately, that just, requires repetition. So the more you see, the better you're going to be. And when I was cramming kind of at the end here, I realized as I went through the essays, I had a panic, like a total freak out moment. Holy shit, I don't know what I'm doing. I got I was kind of looking through business associations, and there was a complicated hypo with like LLC stuff, and I was like, holy shit, I don't have any idea. I mean, it was pretty close. I think I was like 3 weeks out from the UBE, so I'd done a lot of the rule and outlining and MBE, and I knew a lot of the law, right? But when I got in there, I was like blown out on a couple questions. So they do test some pretty like obscure rules and stuff and situations in the actual essay portions of the exam. And really, like, that's why I want to focus on. That's why in the future episodes, I'm just going to go through the previous exams essays, because that is the most useful. The more of those you see, the better, the more breadth of knowledge you're going to know what they're testing and what you need to know. So I kind of like, as I was cramming in those last couple weeks, I was not, writing out full essays. I'm just saying I was trying to actually see as many essays, as many previous essays as possible. I mean, just almost like scanning and speed reading. Like, holy cow, okay, here's the hypo, and then directly to the model, next hypo, next model, next hypo, next model, just like a PDF, right? Go through as fast as you can and read as many as possible. Don't even stop. That's what I did. I didn't even stop because I was so just trying to, in a panic, like, see as much of the exam as possible. And that does help. That's not the ideal way to study. You don't want to be in a panic. You want to give yourself as much time as possible. And that's why I would start looking at the actual essays as early as you can. I kind of forgot a little bit about prioritizing that, I would say, for when I came back into the UBE jurisdiction. So that's like one mistake to look out for. I would start looking at, and I am going to, in this podcast, start looking at with you the actual previous exams, like July 2022, right? California releases the previous exams and model answers. New York also is a UBE jurisdiction, so they have previous exams and model answers. You can kind of look it up. There are states, various states will do the UBE, I think like Maryland and maybe like Wyoming and Montana or something. There, you just kind of Google like which ones have model answers. And you can go through, right? They'll have July and February all the way back to whatever it is, like 1990 or however far back they go. And if you just read through and don't even, like, you're not even studying or asking yourself or outlining or anything, you just read through all of them, that is going to have some utility. You're going to see a ton of the actual test matter and what you're responsible for knowing. So that's kind of just to say, how would I approach my studying? Right now, if I was going to do it all over again, the key takeaways I think are I would really just try and drill in those MBEs every day. I think if you're doing like 30 to 50 a day, that's probably okay. But if you're a little bit green or you really don't know what you're doing, you probably want to do like 100 a day. But I wouldn't like kill myself on timing. You want to know what the timing is like. You want to kind of feel like what is a minute 30, a minute 45, where you want to be in your sweet zone. You kind of want to have a sense of like how you should be moving. Most people that I kind of saw, they finish with plenty of time on the MBE as long as you're moving. I finished with like 5-10 minutes to spare on each, and I wasn't in a hustle, right? I was just you want to just keep moving. That's really, you don't want to pause, you don't want to stop. As you're going through, there are going to be ones that are longer, that are going to take you a little bit longer. Some of them you're going to know really quickly. You're going to read the question, and if you've prepared, then you're going to literally say the correct answer in your head before you move into A, B, C, and D. That's like obviously the ideal. If you could just answer every one of them before you move into A, B, C, and D, you have like a sense of like, okay, I'm looking for this answer. That's not going to be the case every single time. You're going to have to like debate and get in there and weigh some of the answer choices. And like I said, when you get it down to 2, it can really help to be like, which one of these should be incorrect? There's going to be a reason why it's not the correct answer. And you can kind of see that, I think, a little bit easier than trying to convince yourself which one is the better answer. But, as long as you're going through MBEs, I would probably do like anywhere between 30 and 100 a day. I would not do 100 a day like me right now. That's pretty exhausting. Maybe, like I said, it's a marathon, not a sprint. Every day you want to be like doing a manageable amount of bar study. MBE is like pretty taxing intellectually. So I would say 30 to 50 a day. Every single day you want to be doing that though, right? It's probably okay. You're learning the rules, you're getting into it, you're asking questions, and then I would be trying to see actual previous exams, and I would get on that as soon as possible. I wish I would have done that a little bit earlier. The actual exams, right? Even if you don't know the law yet, I would even look at the essays. I mean, I would personally advise that you start looking at those early, because that's kind of how I thought, right? Well, I haven't really gotten into the nitty gritty and the outlines and the actual rules and the laws. I don't have it under my belt, so I'm not ready to look at the essay questions. But then, even when you get it under your belt, they have some really tricky stuff in there. So I would look, even if you just did one a day, that would probably be okay. Just okay, I'm looking at, if you did one every single day, you would do a test like every, one or two essay questions a day, kind of look at it, and then look at the models and take notes on what it's asking you, what you don't know, what kind of things are surprising. That can be really helpful. So get in, do the MBEs, and do like those actual previous exams. That is the most helpful studying from my vantage point, and that's how I'm going to run this podcast as well. We're going to be looking at actual hypos and going through them. So I think that's like the most useful things that you can study. Some people recommend that you take those giant outlines that you can get. I mean, you can generate them with AI, but if you have a prep org, they're going to supply you with the really long outlines and basically boil them down to like attack sheets or an attack outline of like the most critical. I also did that over time. I tried to get like, you're going to get a sense for things that you remember from law school and that are just really easy for you to remember and reproduce. You're not going to need to spend as much time like actually focusing or reviewing those topics. Within the stuff that you're responsible for knowing, there are going to be some discrete topics that you're a little bit more unfamiliar with, or maybe you didn't see in law school, or maybe you're approaching for the first time. I know for property, it went a little bit deeper into like leases, mortgages, assigning versus subleases and all the rules there. They get really nitty gritty on that, and you got to know like what are the effects of each and how do they apply to actual little mini hypotheticals, right? That's going to take a little bit more review, or it did for me. So you kind of want to have like, I would have like an attack outline, like here's the things that, maybe the days before the exam I need to review because I'm not able to just 100% reproduce them. And I'm not sure like exactly the really like fine nuances. I mean, even like covenants versus equitable servitudes, when you have those like elements of what you're responsible for knowing. There's another mnemonic, pints. So privity, intent, notice, touch and concern, and then statute of frauds in writing, right? I mean, some of them do twin, touch and concern, writing, intent, notice. Those elements, you're going to want to know like all of the nitty gritty stuff down to a T on exam day, because they're going to ask you about like how it applies in those hypos on both the MBE, and you could get an essay question with that. So those kind of things, like I didn't know down packed or cold, from law school. It wasn't drilled into my brain. So those kind of things, like if you're aware, like, oh, I know I'm going to need to know this and I don't really have it like memorized yet, I would have like an attack outline where you keep like those topics in each of the things that you're learning, like civil procedure, property, all that stuff. I would actually have like sort of an attack outline of, here are the things that I need to review. I need to keep coming back and seeing. And that's kind of why I like the podcasts. I mean, I was looking for a podcast that would go through the hypos with the rules that I could repeat and review on, especially the topics that you're not as strong in. It's so helpful to listen to it a couple times even, and you can do that when you're chilling. It's not so strenuous to listen to a podcast. So that's kind of why I wanted to produce this for people. I just feel like it's a little bit helpful. This first one, I'm just sort of trying to describe my thinking process and how we approach studying, which hopefully somebody will find something useful in here for structuring their own study plan. Everybody's going to have like things that they know are successful for them, that they have used in law school. Don't deviate so drastically. Whatever works for you, keep doing that. You're going to want to develop your own game plan for, how am I going to feel comfortable when I go into the bar exam? When I go in there, I'm going to need to know and be able to reproduce cold all of the elements for the most critical rules. And if you don't know like the most crazy off the wall, like exception to the exception to the exception random rule, you're going to be fine as long as you really have a conceptual grasp and you're able to reproduce those elements that are like the most high yield topics. And you can even, like in AI and stuff, use that verbiage, high yield. Give me the high yield rules. You want to have those high yield rules down cold so that you're like memorized. And you can and you don't have to think. Those should be second nature. As long as you're you're doing that, you're gonna be fine. I feel like don't panic. As long as you're trudging, don't get too tired, don't burn out. I did a lot of passive listening and a lot of review that way. Let people kind of study for you with podcasts and so on. You're gonna want to know all the rules on exam day, and it's a marathon, not a sprint. You're just, repetition. So the more you see something, the easier it's going to be to remember. So you want to see as much and as many questions and exam questions as possible before exam day, so that you're getting that repetition naturally by just seeing, the questions over and over again. For instance, like on the MBE, pretty much every bar exam will have a question that tests removal, but they like to test the exception, which is if the defendant is at home in the state that you're being sued in. Like the defendant is at home in B, and they get sued in state court in state B. Like they can't remove, even if you have those the $75,000 exclusive of interest and costs, right? And amount in controversy exceeds $75,000, and you're diverse. So the plaintiff is A, defendant is B. They can't remove if they're in the forum state. If they're at home in the forum state, the defendant is at home in B, and you're in the B state, even if you meet those requirements for diversity jurisdiction, the defendant can't remove. They love to test that rule and those exceptions and so on. Those are high yield topics. You're going to see them on like most of the previous exams and so on. You kind of want to have those down. That's why I would focus on those 7 MBE topics. Have everything there really under your belt, and then if you get like the wild off the wall random stuff, you're just going to have to deal with it the best you can. And like I said, you can make up a reasonable rule. And as long as you're showing the bar examiners, I know how to approach the analysis, and I know what my job is here. I'm supposed to structure the actual essay. You're going to do fine, right? I mean, it's almost like when you think about it, like somebody who's clerking for a judge or something, they want that opinion to be looking a certain way. And you just kind of want to follow that formula, that legal formula. You want to kind of have that down. And if you don't know every single last little law, I mean, there's a lot of rules that you're going to be responsible for knowing. Don't panic. You're going to be fine. Just try and have all the heavy-hitting, high-yield topics under your belt, and it's going to go well for you. Speaking of which, okay, I'm going to go through actually right now. I've got an outline that I made here for my prep. If you don't have a prep org, this will be useful for you. If you do have, and you're paying for a prep, and this is sort of like a supplemental podcast for your studies, then you probably don't have to listen to this. They will actually structure all this out and have all of the outlines and topics that you need to know, and you can refer to that. But if you don't have a prep course and you're kind of teaching yourself, which is what I did, you would want to know, like, okay, what do I need to know in every topic? So let's start with civil procedure. You need to know jurisdiction and venue. So you got to know federal subject matter jurisdiction. That's what we touched on a little bit. Diversity jurisdiction, right? Federal question, supplemental jurisdiction, and removal. Those are the important things you got to know. You got to know personal jurisdiction, purposeful availment, all of those key words within personal jurisdiction you got to know. Service of process and notice, venue, forum nonconvenience, and transfer. There's your jurisdiction and venue topics. You got to know all that stuff down cold. Within those, right, there are all those key phrases that you're going to have to know and memorize that we're going to go through in future episodes. But right now, I'm just trying to do the outline for what do you actually need to know. In continuing in civil procedure, you have to know the law that is applied by federal courts, the Erie Doctrine. All right, so you got to know state law in federal court, federal common law. You gotta know, like, within federal courts, right? That's what California and the UBE are applying federal law most of the time. You're gonna want to know all those little hairy nuances in Erie for when you're applying the actual state law and when you're applying federal procedural law and so on. There are all those little hairy exemptions and things you gotta know. Okay, pre-trial procedures. In civil procedure, as the lawsuit progresses, and you'll find in your practice, civil procedure is the most important and useful of all the topics. You've got to know let's go ground level from start to finish, all the stuff you got to know. Preliminary injunctions and temporary restraining orders. They kind of want you to know when you can get those and what are the requirements. Pleadings, that's your complaints. That's the initiation of a lawsuit. You got to know how to properly plead a complaint. You got to know, all those standards within starting and initiating the lawsuit. So amendments, how do you amend the complaint? And supplemental pleadings, all the standards there. Rule 11, right? When you bring your lawsuit, Rule 11 sanctions. Did you do it for an improper purpose? And can the court actually punish you for bringing a shitty lawsuit that is harassing somebody? And the safe harbor provisions, right? They can't just bring a Rule 11 motion. You got to kind of know, like, hey, if I'm practicing and I do a shitty thing and I sue somebody for something I probably shouldn't, the court may get mad, but the defendant will want to, slam you. They're going to threaten you. Hey, I'm going to bring a Rule 11 motion. They can't just do it, right? They have to give you an opportunity to cure. You got to know Rule 11 sanctions, how they proceed, how that works out. Joinder of parties and claims. This is including class actions, which is what I was practicing in California. You got to know all the little nitty-gritty nuances there. Discovery, okay? What can I actually discover in a lawsuit? What can I get from you? What can I force you to give me? This is going to include just like routine discovery, which is you got to know the three big ones are interrogatories, RPDs, requests for production, and depositions. You kind of have to know, like, how can I take a deposition of someone? What are the restrictions on me and my capacity to do that? And the request for admissions, right? The three like written discovery things you got to know kind of the nuances of are, again, request for production of documents, interrogatories, and the request for admission. And also, like, kind of the stuff about depositions. How can you do that? Disclosure, right? In federal court, you have initial disclosures. When do you do that? And also, expert discovery. That has all those standards that you kind of have to be responsible for. So if I want to bring an expert in and have them testify, how can I do that and why? And then let's see, adjudication without trial. You kind of want to know, like, when do you actually see a jury versus when it might be a bench trial. They got really, nitty gritty on this for whatever reason. When I took the bar in California, there was a ton of questions about, like, when does something get submitted to a jury and how it gets submitted to the jury. I don't know if those were experimental or not, but that was something that kind of blindsided me. There was some of those I didn't know. So that's kind of something you want to be a little bit aware of. And then, like, pre-trial conference and order. Okay, yeah, you want to know about that. And for jury trials, right? Who has a right to a jury trial? Like I said, who's actually, when is it going to be a bench trial? How do you select and how is the jury comprised? How do you, they have those vetoes. When you do voir dire, when you're selecting who's going to be on the jury, how can you actually exempt people that you don't like, and know a little bit about that process. Okay, and let's see, requests and objections for jury instructions. This was tested. They wanted to know, like, jury instructions is a little bit of an obscure topic, but you're responsible for knowing how do those jury instructions get in front of the jury, and kind of what do they look like, and what are the restrictions there. Motions, these are pretty big. So the big ones that you're responsible for knowing are motions for summary judgment, MSJ. You want to know the standard, right? I mean, genuine dispute of material fact. You got to have that sentence down cold. So you got motions for summary judgment. When do you bring them? Why? How do they work? How does it get presented to the judge? How would he rule on it? Motions for judgment as a matter of law, the JMOL, which used to be the JNOV. You got to know, when do you bring them? They really get into all of that nitty gritty. During trial, right? When can you bring it? And then afterwards, a renewed motion, renewed JMOL. Like, when can you do that? And what do you have? What are the prerequisites? You have to do it before trial. You have to have brought one. You have to have brought a JMOL properly to have a renewed one. You can't just do a renewed JMOL if you never did one in the first place. Post-trial motions, motions for relief from judgment and for new trial. They want you to know about that. Verdicts and judgments. You got to know about defaults and dismissals. Jury verdicts, the types and challenges. I always liked learning about... what do they call that? Jury nullification. That was really interesting to me, right? Like, holy cow, you can just, even if you don't believe in the law, you can just say somebody's innocent even though they're not, and that's allowed. That's crazy. Right? Claim and issue preclusion, res judicata. You're going to have to know all the nitty gritty there. As far as claim and issue preclusion, there are some nuances there, and, you're responsible for knowing what is a final judgment and how all that interrelates. Appealability, you got to know about availability of interlocutory review. That's kind of a tricky one that you might have to review. The final judgment rule, like I said, scope of review of the judge and the jury. You got to kind of have an idea of what's going on there. And that's pretty much it for CivPro. 2, right, constitutional law. Here you've got to know the nature of judicial review. That's the organization and relationship of state and federal courts in the federal system, right? We have the system of federalism. You kind of have to know a little bit about that. Jurisdiction. When does Congress have power to define and limit? Right, and that's the 11th Amendment and state sovereign immunity doctrines. You have to know those. Judicial review in operation. So the case and controversy requirement. Got to know about that. Let's see here. Political question and justiciability, right? The justices don't do anything in foreign policy. Unfortunately, they can't really regulate anything there. That's not within their purview. The separation of powers. So the powers of Congress, that's going to be a big topic within constitutional law. You've got the Commerce Clause, taxing and spending powers. That's huge. War, defense, foreign affairs, kind of how those work, and treaties, right? All that stuff. Power to enforce the 13th, 14th, and 15th Amendments. Within constitutional law, they're really concerned about actually how the Constitution applies to the states. So you kind of have those like throwaway sentences memorized. The powers of the president. So as the chief executive, what can he do? The take care clause. Treaty and foreign affairs powers, appointment and removal of officers. That's really annoying and takes review. Like, how does he actually appoint people and who can he remove? That gets really nitty gritty. Federal interbranch relationships. You got to know the congressional limits on the executive. What can Congress limit the president from doing? The presentment requirement and the president's power to veto or to withhold action. It's good to know the non-delegation doctrine. I don't think that's heavily tested. It's kind of annoying that you have to know that, but it's good to know the non-delegation doctrine. Executive, legislative, and judicial immunities. You want to know a little bit about that. Let's see. Right, federal immunity from state law. State immunity from federal law, including the 10th Amendment. So those immunities are you got to know all the little nuances there. The negative implications of the Commerce Clause. So we talked about the Commerce Clause just briefly, but the dormant Commerce Clause, you got to know about that. The Supremacy Clause and preemption. So there's those different kinds of preemption, field preemption, obstacle preemption. You got to know about preemption. Authorization of invalid state action, of otherwise invalid state action. Got to know a little bit about that. So the individual rights, this is huge, discrete topic in con law. You have to know this. These are the levels of scrutiny, right? So this gets applied and it's tested heavily in the MBE. For sure, you're going to see questions about this, and it might be an essay question. What constitutes state action? You got to know about due process, right? Substantive due process, those are your fundamental rights, and your other rights and interests, like procedural due process. So the difference between substantive and procedural and when those come into play. You got to know about equal protection. Those are the fundamental rights. Classification subject to heightened scrutiny. And that's kind of where you break into the standards of scrutiny: strict scrutiny, intermediate scrutiny, and rational basis. Those are the things that you got to have down cold. When do those apply? If it's race or national origin, if it's sexual orientation or gender, and then when the government just has pretty much everything else, kind of the catch-all rational basis. You got to know when those get applied and how. The takings clause, you got to know about that. So what constitutes a takings from the government, eminent domain, and regulatory takings. Can't forget that. Privileges and immunities clause, the contracts clause, unconstitutional conditions, bills of attainder, and ex post facto laws. Those are kind of like the other discrete topics that you might want to know. Ex post facto laws, that's not high yield, I don't think. So if you don't, if you're going to throw something out, maybe that one. First Amendment, you got to know all about the First Amendment. So that includes freedom of religion, separation of church and state, right? The free exercise clause, the establishment clause, That's for religion. And then for your First Amendment freedoms, this is commonly tested within the essays. They're going to have, the First Amendment protections. So you got to know when it's a content-based regulation of protected expression, when it's content-neutral regulation of protected expression, regulation of unprotected expression, regulation of commercial speech, which also has its whole other little rule nuance there, regulation of or impositions upon public school students, public employees, licenses, or benefits based on the exercise of expressive or associational rights. There was an essay topic in the UBE about this specifically when it was a school student and some regulations done by the principal. So that's kind of a niche little area of freedom of speech that has been tested. So unfortunately, you have to know that. Prior restraint, vagueness, and overbreadth. You got to know that. And that kind of covers constitutional law. Next, we've got contracts. Contracts, the heavily tested, you got to know, down pat cold, is the formation of contracts. So you got to know mutual assent. What is that? What constitutes that? Offer and acceptance, right? Unilateral, bilateral, and implied in fact contracts. You got to know the distinctions and the nuances there. By the way, in contracts, I worked with a guy, he was a really funny guy, but he actually, the big overarching thing is you got to know the difference between the UCC and service contracts. Like when it's an article or when it's goods over $500, there's like separate contract law, right, that applies, and that is really concerned with like merchants and all that whole field of law. You got to know that, and then distinctly separately, there's like service contracts, the common law basically. So common law and UCC, those two, every contracts question is going to boil down to, is it first question number one, is it UCC or is it common law? My buddy that I mentioned, he actually got a contracts and analyzed under the common law when it was a UCC question. So he actually failed the bar exam because of that. But he was a really great lawyer. So if you do fail the bar exam or you make a critical mistake, just know that you can recover, know what mistakes you made, and you're going to be fine. Taking it again, obviously not ideal, but definitely number one, overarching contracts, got to know if it's UCC or if it's common law. Okay, so, within that, in the formation of contracts, offer and acceptance, unilateral, bilateral, and implied in fact contracts, they get treated differently based on whether it's UCC or common law. So that's kind of why you have to know it. All these rules get a little nuanced, exceptions and so on that are different based on what you're in, whether you're in UCC or you're in common law. You got to know, consideration. This is like one of those sentences that you have to have. It's a bargain for exchange of value. Just be able to reproduce that on exam day. You got to know the obligations that are enforceable without a bargain for exchange, including reliance and restitution. All those various damages. Obviously, expectation damages are your go-to. You have to know all that. And modification. When can I modify a contract? How? You have to know all the little nuances there. Defenses. So you got to know the defenses to enforceability of a contract, right? A, incapacity to contract. B, duress and undue influence. C, mistake and misunderstanding. D, fraud, misrepresentation, and non-disclosure. E, illegality, unconscionability, and public policy. F, statute of frauds. So all those defenses, you have to know all the nuances, and you're going to want to have it down pat cold what's going on in those on exam day. All right, parole evidence. That comes up very frequently. You have to know parole evidence, what it is, when it applies, interpretation of a contract, how do courts interpret contracts when there are ambiguous terms, when there's disagreement, right? How's the court going to interpret the terms? You got to know that. The omitted and implied terms of a contract, kind of how those are treated. Performance, breach, and discharge. You got to know all about performance, breach, and discharge. The conditions, the excuse of conditions. When are you excused from not fulfilling your side of the deal? Right? Within this, you kind of just want to think like common sense. Who would be suing who over a contract and why? Know about it. when is it a material breach versus a partial breach? Anticipatory repudiation. When are you allowed to repudiate a contract versus when are you not allowed to? The obligation of good faith and fair dealing. You're going to want to have that ruled down because that's going to apply to pretty much every contracts question. You have a duty of good faith and fair dealing. And what does that mean? Express and implied warranties in sale of good contracts. You got to know that. Other performance matters including cure, identification, notice, and risk of loss. Who bears the risk of loss? There's all those shipping contracts. Oh, those are fun. You got to know all about the shipping contracts. On delivery versus point of sale. Who bears the risk of loss? Those get tested very heavily. Impossibility, impracticability, and frustration of purpose. You have to know all those. Know those cold. Discharge of duties, including accord and satisfaction, substituted contract, novation, rescission, and release. Ooh, nitty gritty. You got to know those terms. What do they mean? When do they apply? And your remedies, right? At the end of contracts, those are your remedies. Kind of touched on those. Expectation interest, restitution, consequential damages. They have to be foreseeable, right? Causation, certainty, and foreseeability. Liquidated damages and penalties. When are those enforceable? Avoidable consequences and mitigation of damages. You have a duty to mitigate. You got to know what that means and how to apply it to a fact pattern. Rescission and reformation of a contract. Have to know that. Specific performance and injunction. Reliance and restitution interests. And remedial rights of breaching parties. Within contracts, you want to know all about that. And right, there's going to be nuances depending on if it's a UCC contract that you're analyzing or if it's common law. Third-party rights, third-party beneficiaries. When can a third party enforce a contract between two other people? That's really nuanced. Assignment of rights and delegation of duties. When can you assign and delegate duties under a contract? And that's going to take you through contracts. Nice. If you know all that, you're going to do great. Just go to AI, take notes on all those different topics, and ask about, hey, what does this mean, and what do I need to know? And you're going to do great. Criminal law and procedure. Let's go through those. All right. So you got to know all the different crimes and the elements. So what constitutes a homicide? You've got intentional killings, right? First degree murder, premeditation, deliberation, provocation. You got to be able to go through the first degree murder elements and know them down cold. When are you going to be convicted of first degree murder? And when is it going to be involuntary manslaughter? Right? You've got unintended killings. So that's for an unintended killing, you've got to know the elements. Intent to injure, reckless and negligent killings, felony murder, misdemeanor manslaughter. Those are your unintended killings that you're responsible for knowing about. You got to know the elements. When are you convicted of felony murder and why? Now, for the other crimes, there's a whole list of crimes, and you're going to want to know all the elements. We're going to go through those on essays in future episodes. But what are you responsible for knowing? You got to know about theft and receiving stolen goods, robbery, burglary, assault and battery, rape and statutory rape. But I've never seen that tested. You got to know it, but maybe a little bit less time on that. Kidnapping, arson, possession offenses, and then you've got your inchoate offenses. So what is an inchoate crime? You've got attempt, conspiracy, and solicitation, right? You didn't actually do the crime, but you're still guilty of a crime. Attempt, conspiracy, and solicitation. Inchoate offenses, got to know those. Right, general principles of crime, you've got to know about acts and omissions. State of mind, right? That's the mens rea. You've got a required mental state. Strict liability, mistake of fact or law, responsibility, mental disorder or intoxication, right? There's these get out of jail cards, kind of, that you got to know. You've got constitutional protections of an accused person. That's a huge discrete topic. That came up on my California bar exam. So in this field, you got to know about arrest, search, and seizure. What constitutes an arrest? What constitutes a search? What constitutes a seizure? Confessions and privilege against self-incrimination. You've got to know that whole field, right? Miranda rights. When are you actually in when you're actually in an interrogation? What constitutes an interrogation? You've got to know about lineups and other forms of identification. Your right to counsel. How do you invoke the right to counsel properly? When does it apply? Fair trial and guilty pleas. Double jeopardy. Cruel and unusual punishment. Burdens of proof and persuasion. And an appeal and error. Appealing criminal convictions and error. You got to know that. And that's going to take you through criminal law, thankfully. So evidence. Next topic is evidence. So in evidence, you've got to know the presentation of evidence. So that's introduction of evidence. Requirement of personal knowledge. Requirement of personal knowledge. Refreshing recollection. Objections and offers of proof. Lay opinions. You got to know about that. So let's see. In evidence, you've got impeachment, contradiction, and rehabilitation. Inconsistent statements of conduct. Bias and interest. Conviction of a crime. Specific instances of conduct. Character for truthfulness. Ability to observe, remember, or relate accurately. Impeachment of hearsay declarants. When does something constitute hearsay? What are the hearsay exceptions? What is non-hearsay? Right? These are all just little nuances within evidence that you're going to have to know about and have down cold for the rules that you're responsible for knowing on exam day. How do you rehabilitate an impeached witness? How do you properly impeach a witness? Character evidence, when can you bring it into play? Like when can you only talk about reputation versus specific instances? That's really important. Ask AI all about when can I bring in specific instances? When am I only allowed to testify about reputation and so on, right? Opening the door to character evidence. When can you open the door? How do you open the door to character evidence? Who can open the door to character evidence? What is the prosecution barred from arguing? Those are all things that you're going to want to know and have down packed for exam day. And like I said, relevancy, basically start out every evidence essay is going to start with relevancy. Probative value. So probative value, the exclusion for unfair prejudice, confusion, or waste of time, that 408 exception is really heavily tested. That's going to be applicable to pretty much any evidence essay. So you just want to have that ruled down. Okay, authentication and identification. So how do you authenticate evidence? Right, chain of custody issues, got to know all about that. Character and related concepts, we talked about that. When is character admissible? When can you talk about it? Methods of proving it. Habit and routine practice, there's an exception that you want to know. Other crimes, acts, transactions, and events, and you want to have the exceptions like prior sexual misconduct of a defendant, right? If he's convicted of some kind of sexual crime, they're not as lenient. If you're a perv, the law is less concerned with you. Expert testimony. What do you need to know for the qualification of the witnesses? The basis of their testimony, the ultimate issue rule, reliability and relevancy, and what is the proper subject matter for an expert? You gotta know all about that. The privileges, right? For evidence, you have to know all about the privileges, the spousal immunity versus marital communications privilege. Those are two separate doctrines, and they're very nuanced for when you can invoke them and their effects on evidence. So spousal immunity and marital communications, attorney-client and work product, physician, psychotherapist, and patient privilege. You got to know when those apply and if they apply. When do you get to invoke your privilege of speaking with your physician or your psychotherapist? And when can you not, right? There are these exceptions. Insurance coverage. When can you talk about insurance coverage and when can you not? Remedial measures, right? This is within privileges. When can you talk about somebody implementing remedial measures and fixing like a pothole or whatever? Compromise, payment of medical expenses, and plea negotiations. You have to know about a little bit about that. Maybe not so much about that, right? But that's not like a high yield topic, but know about it. Writings, recordings, and photographs. This is big within evidence. You have to know When can you introduce a writing? When can you introduce a recording and photograph? This is the best evidence rule. You got to know that one down cold. What are the requirements there? Hearsay and circumstances of its admissibility. This is a big one, and we're going to be going through this almost certainly in evidence essays. What is the definition of hearsay? What is it? Prior statements by a witness, statements attributable to a party opponent, multiple hearsay, right? Hearsay within hearsay. Oh man, it gets so complicated. Present sense impressions and excited utterances. You have to know what qualifies as a present sense impression and an excited utterance. Exceptions to hearsay. Statements of mental, emotional, or physical condition. Right? These are the hearsay exceptions here. Statements for purpose of medical diagnosis and treatment. Past recollection recorded. Business records, public records and reports, right? There's a whole nuance here. You got to know business records and public records. There are two different standards there for when they're going to be admissible evidence. Learned treatises. That one's not tested as much, but you got to know it. Former testimony and deposition. So when somebody has actually come on and done a former, they've actually submitted testimony, like in a deposition, that can get in as evidence, right? Statements against interest, other exceptions to the hearsay rule. You got to know all those hearsay rules and their exceptions. That's the main bulk of your evidence study. You got to be within that. Okay, we only have two more topics, thankfully. Real property. So within real property, they're really concerned with the ownership of real property, present estates and future interests, and how they get designated and categorized there. You've got present estates. That's your fee simple, your defeasible fees, and life estates. Oh man, you got to know the nuances of all that horrifying vocabulary. What is a defeasible fee? What is a fee simple? Life estates, right? And then those are all present estates. And then future interests. Okay, so you got to know the difference between a reversion, a remainder, that's vested and contingent. Remainder could be vested or contingent. Executory interests, possibilities of reverter, powers of termination, rules affecting these interests, including survivorship, class gifts, waste, and cypre. So all those, so a reversion, a remainder, and a possibility of a reverter, there's going to be nuances within those of who steps in, who gets the actual property. Within property, you're basically asking yourself, like, who owns this or who's liable for something? Pretty much the whole time, you're just like, whose is this shit? And why? So you got to know the nuances of a reversion, a remainder, and a possibility of reverter. That's kind of annoying. Co-tenancy. So you've got tenant in common and joint tenancy. Those are two separate things that you have to know. Distinctions. When is it a tenant in common and who owns it? And how do they dissociate? How do they sell their piece? And what's the effect if they sell it? You got to know all about that. Rights and obligations of the co-tenants. So if somebody decides that they want to use the property in a certain way, or they want to sell it, or they want to collect rent, who gets the rent, why? You got to know all about that. Partition. Let's say you want to split it, right? Partition in kind versus partition by sale. You got to know, when does that happen? When does it? The court doesn't want to. They don't really like certain ways of partitioning a property. So you kind of want to know, what is the court going to think and do in certain instances when there's a dispute over the land? Are they going to want to sell the land actually and then give each person like money? Or are they going to want to like split it down the middle and go, okay, this part's yours, this part's yours? When do they do that and why? Severance. Let's see. Relations among the co-tenants. How do they relate to each other? Landlord-tenant law. So here you've got the types of tenancies, possession and rent, transfers by landlord or tenant, termination, including surrender, mitigation of damages, anticipatory breach, and security deposits, habitability and suitability, right? You've got those requirements. The landlord has the covenant of habitability. He's got to make it habitable. And you got to know, like, if something stops working or something breaks in the apartment, when can you withhold rent and why? Special problems. You've got the rule against perpetuities. I guess they don't test that as much anymore, but it has appeared. So that is annoying that you have to know that, but know the rule against perpetuities. Common law rule and statutory reforms. Okay, alienability, descendability, and divisability of present and future interests. When is it alienable? When can you sell it? When is it descendable? When can you pass it down? And when is it divisable? And the nuances between those little words there. Fair housing and discrimination, conflict of law related to disputes involving real property, restrictive covenants. You got to know, when is it a restrictive covenant, the nature and type, the creation of a restrictive covenant, the scope of a restrictive covenant, what kind of behaviors can you actually restrict on your land. Transfer, how do you transfer the actual restrictive covenant? Does it pass down to people who buy the land? Termination, property owners association and common interest ownership communities. That's like, if you have a subdivision or whatever, when do you need notice and not. Easement, profits, and licenses. You have to know what those are and the nature and type, methods and creations, whether they're express or implied. Prescription, which is kind of the adverse sort of a deal. Scope and apportionment, transfer, and termination of those interests. Fixtures on the land. If you install something, when does it go with the land and when does it not? Zoning. Those are, fundamentals other than regulatory takings. You got to know about the zoning laws, how they apply, protections of pre-existing property rights, and rezoning, spot zoning, and zoning changes, right? You got to know, how does that work? Real estate contracts. You have to know about real estate brokerage a little bit. Creation and construction. That's statute of frauds and exceptions, essential terms, time for performance, remedies for breach. Marketability of title, that is tested commonly. That was in the bar exam for me. Equitable conversion, including risk of loss. Options and rights of first refusal. You have to know about that. Fitness and suitability and merger. Mortgages and security devices. For me, that was, we didn't cover that so heavily, I guess, in my law school property class, but you have to know all about mortgages. For the bar exam. Types of security devices, mortgages, including deeds of trust and the difference there. Purchase money mortgages. That's pretty key as opposed to a mortgage. And when somebody defaults, right? If somebody defaults on a loan, who gets to foreclose and why? And the extinguishing of those junior mortgage interests. How does that work? Who gets the house? Who gets paid? And why? Future advance mortgages, installment land contracts, absolute deeds as security. All right, security relationships. You got to know necessity and nature of the obligation. Mortgage theories, whether you're in a title, a lien, or an intermediate jurisdiction. So the mortgage theories gets tested, especially on the MBE and also essay questions. Rights and duties prior to foreclosure, the right to redeem and the clogging the equity of redemption. That's like, if you want to try and get out of the foreclosure, how can you do it? And what are your options there if you're the actual person who's being foreclosed on? Transfers by a mortgagor, assumption and transfer. What are your rights and obligations there? Application of subrogation and suretyship principles. That's kind of nuanced and you might want to review that. Restrictions on transfer. How can you restrict and why? The discharge of the mortgage, the payment, and the deed in lieu of foreclosure. You got to know about those things. Foreclosures, right? Types, how do you accelerate? That's the bank usually accelerating for failure to pay. So how does that work? When can you do it? Parties of the proceeding, deficiency and surplus, and the redemption after foreclosure. And then, in property, you've got your adverse possession, transfer by deed, requirements for the deed, types of the deed, right? You got a general warranty deed, and you got to know the different types there and how do they apply. Drafting, review, and negotiation of closing documents. That's not super heavily tested. That's not like probably super high yield, but you want to know about that. And let's see, who's authorized to execute documents and why. Transfer by operation of law and by will. for mortgages, right? In general, there's redemption, exoneration, and lapse. Maybe not the most high yield, but you want to know about those. Title assurance systems and the recording acts. Recording acts is heavily tested on the MBE and the essay questions. So indexes, chain of title, hidden risks, notice when you need all that stuff. You got to know that stuff. And then finally, your last of the MBE heavily tested high yield topics is torts. You've got your intentional torts. That's harms to a person such as assault, battery, and false imprisonment. Infliction of mental distress. When are you going to be on the hook for that? And when are you not? Harms to property interests such as trespass to land and chattels, and conversion. Little overlap there with crim. Defense to claims for physical harms. You've got consent, privileges and immunities, protection of self and others, protection of property interests, parental discipline, protection of public interests, necessity, incomplete privilege. Those are your intentional torts. You got to know all about those and how they work. Negligence, that's your typical duty breach, causation, damages. The standard of care, right? The reasonably prudent person standard. And how it differentiates if it's a child or if you're like a professional, like a doctor. You got to know the nuances there. If you're physically or mentally impaired, how does the standard of care differentiate for you? And the special classes. Rules of conduct derived from statutes and custom. Got to know about those. Problems relating to proof of fault, including res ipsa loquitur. Res ipsa loquitur, yeah, that's like a special one that you want to know about, right? Just refresh your recollection on those rules that you probably learned in law school. Problems relating to causation, but for and substantial causes, harms traceable to multiple causes. If there's like, one fire starts over here and then there's a separate fire and they merge or whatever, you got to know who's going to be liable. You're always asking yourself in these law school exams, who's liable, who's on the hook, who has to pay who and why. Questions of apportionment of responsibility among multiple tortfeasors, including joint and several liability. Limitations on liability and special rules of liability. You got to know about those. Employees and other agents, right? This is your vicarious liability. When are you on the hook as an employer versus when is the employee on the hook for their own acts and independent stuff that they do. Non-delegable duties. Right, contractors, independent contractors, the nuances there. Defenses, contributory fault, including common law contributory negligence and last clear chance, and the various forms of comparative negligence. Assumption of risk. Separately, you've got to know about strict liability and products liability. Those are clutch topics that you're going to want to know. For instance, in strict liability, you've got like abnormally dangerous activities and defenses therein, and manufacturer liability, right? If they produce a defective product, when are they going to be on the hook and why? Got to know all about that. And then other torts, you've got the nuisance claims, private nuisance, and the defenses, claims on defamation and invasion of privacy, defenses and constitutional limitations. So you've got just outright defamation and then those invasion of privacy claims. Claims of misrepresentation and those defenses, and claims based on intentional interference with business relations. You have to know about those things. And boom! If you know all about those quickly through the 7 MBE topics, you are going to be well prepared for the bar exam. That's kind of the overview of what you're responsible for knowing. So if you don't have a prep course and you go through all of those topics and you understand all the rules and the nuances, then you're going to do great on the bar exam. All right, awesome. So this is the first introductory episode here. In the future, we're going to be going through actual hypos and essays and helping you get through and prepare for the bar exam. So thanks for your time. This is TJ, and you're listening to the Bar Exam and Chill podcast. I'll see you next time.